Hey guys, welcome back to my channel and thank you for joining me for another true crime video. I hope you guys are all having a fantastic day so far. Today we are discussing the Karen Read trial yet again. On July 1st, the jury were unable to come to a unanimous verdict. They were at an impasse and Judge Cannoni swiftly declared it a mistrial. And I was under this crazy notion that we wouldn't really be hearing too much about the Karen Read trial other than some hearings here and there as they prepare to retry Karen Read, because basically the same day that this was declared a mistrial, the DA came out and said that they have every intention of retrying Karen Read, which I think they kind of jumped the gun a little bit there. I think they probably should have waited, because as things came out and rose to the surface, it's not really looking too good for the prosecution at this moment. And then it just gets worse because the defense attorneys allege that multiple jurors have come forward kind of voicing their concerns regarding some of the charges that Karen Read was facing, suggesting that the jury came to some unanimous verdicts on some of those charges. And since then, the defense attorneys have filed a motion to dismiss those charges against Karen Read using the double jeopardy, meaning that a defendant cannot legally be retried for the same crimes if she was acquitted for those crimes. But because if this trial is anything, it's just a mess. It's just a mess. And of course, as expected, the prosecution has filed some documents in opposition of those motions to dismiss. So this hot mess of a web continues to spin. So let's go ahead and dive right in because we've got a lot to talk about. So as a quick review, Karen Read was facing charges after she allegedly hit her boyfriend, Officer John O'Keefe, with her car after a night of drinking and leaving him in the snow to die. She was facing 3 charges: second-degree murder, which implies intentional murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing injury or death. 9 weeks of trial, 75 total witnesses, hundreds of evidentiary exhibits, and 5 days of deliberation, and the jury was hopelessly deadlocked, unable to come to a unanimous verdict.
Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service.
So as we see, the judge swiftly declared this a mistrial. Neither the prosecution nor the defense really had any say. The judge didn't really ask them if they had anything to say about it, nor did they object to anything that was going on. They didn't really seem to voice their concerns either, which I thought was quite bizarre. But what struck me as odd is that Judge Cannoni didn't take the liberty of polling the jury to see what they had to say, nor asking the jury if out of those 3 charges, if they were able to come to a unanimous verdict on any of them. And if she had, we wouldn't be in the mess that we're in today. And considering how much time and energy and money and all of the reputations that have been ruined and dragged through the mud throughout this trial, I am just so surprised that she didn't just take the extra 5 or 10 minutes just to tie up any loose ends. I was even more surprised that neither the defense nor the prosecution brought this to the attention of the court. It seems as if it would be in the best interest of everybody if somebody would have spoken out and said, hey, shouldn't we poll the jury? Shouldn't we see if there were any charges that they were able to come to a unanimous verdict on? But nobody did that. So the jury was dismissed and the court basically went on to scheduling the next hearing. Now, about a week after the trial was declared a mistrial, Alan Jackson submitted a motion to dismiss based on some of the jurors' statements. Now, it goes through how the jurors were properly identified to ensure it wasn't just some Joe Schmo off the street making these false claims. So they were properly identified, and they were identified as juror A, B, C, and D to protect the anonymity of these jurors. It says on Tuesday, July 2nd, 2024, so just a day after the trial was declared a mistrial, I was contacted by Juror A. Juror A told me that he or she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that he or she wished to be respectful of the privacy of deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that he or she believes it important to disclose such results because he or she believes that those results significantly impact Miss Reed's rights. Juror A told me that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder was off the table, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. Neither Miss Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Nor did the court on its own inquire of the jury foreperson on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the other counts. Had the court so inquired, it appears clear that not guilty verdicts would have been recorded for count 1 and count 3. Miss Reed was denied her right to receive those verdicts in her favor. So this represents a very big issue in this trial. And again, I should not be surprised. Now, this entire debacle is really the cherry on top of this shit show of an investigation, of a trial, all of the above, because nothing seems to have been done properly. Now, the defense claims that they did not have an opportunity to say anything before the trial was declared a mistrial. Like they were saying that the court failed to inquire and ask the jury if there were any charges that they were able to come to a verdict on. That didn't happen. And now we're at this point where the jury, or a few members of the jury, are saying that they came to unanimous verdicts on charges 1 and 3, or counts 1 and 3. And if they came to a unanimous verdict on those charges, Karen Reed should not face retrial on those charges. The failure of the court to ask those questions and to get clear answers and to tie up those loose ends, that shouldn't land on the fault of Karen Reed. So it's just a huge mess. It is a huge mess. Now, Juror B and Juror C, essentially, they didn't reach out themselves. It was basically they were speaking to a friend and they were in like a group text type of thing, a group chat, talking about what was going on in deliberations. And a friend screenshotted that and then sent it to another friend. And then that friend came forward and spoke to Alan Jackson. I believe it's Alan Jackson, somebody on Karen Reed's defense team, voicing concerns that they don't believe that Karen Reed should face a retry on all of those counts. Another day, on July 3rd, 2024, Attorney Yannetti was contacted by 2 different individuals, Informant B and Informant C. So again, these aren't the jury members themselves. These are people who had received information from two distinct jurors, both of whom were part of the deliberating jury in this case. Informant B sent Attorney Yannetti a screenshot he or she had received from someone, intermediary B, of text messages that intermediary B had received from juror B. In that screenshot, juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. I thought the prosecution didn't prove the case. Informant C had been in contact with another individual, intermediary C, who was a co-worker and friend of juror C, and joined a Zoom meeting during which C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what juror C revealed in the Zoom meeting. So this is basically what's going on in this Zoom meeting. No consideration for murder 2. Manslaughter started pulling at 6-6, then ended deadlock at 4 no, 8 yes. Informant C. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip. That was all confusing. She should have been acquitted. I agree. Yes, the remaining charges were what we are hung on, and that instruction paper was very confusing. So the jury's unanimous conclusion that Miss Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes re-prosecution. What constitutes an acquittal is not to be controlled by the form of the action in question, and they kind of cite some case law. The mere presence of the absence of checkmark on a form is not dispositive. Here, the attached affidavits by Attorney Yannetti and Jackson reflect statements by 3 deliberating jurors on the jury had reached final and unanimous conclusions that Miss Reed was not guilty on counts 1 and 3. There was nothing tentative about the juror statements. To the contrary, they were definitive in describing the results of the jury deliberations. So, like I said, the first juror, Juror A, seemed to have reached out directly. Juror B and C were talking to friends and friends of friends, and those friends, kind of a game of telephone, then relayed that information to either Alan Jackson or David Yannetti. And they seem to have the same story, the same lineup of what they determined in that jury room. And it seems at the very least, if you're looking for truth and justice, that they should do a voir dire of these jury members and ask even a simple question. Like, you don't have to really go into the process of deliberation, but even go ask them a simple question. Did you come to a not guilty verdict on any of the charges? And then perhaps ask, were you under the assumption or the belief that the jury in its entirety had that same conclusion? And then it didn't stop there, because a 4th jury member came forward and had basically the same things to say. So Alan Jackson submitted a supplemental affidavit to support the motion to dismiss. And he said that on Monday, July 8th, 2024, I was contacted by Juror D. Again, all of these jurors are A, B, C, and D to protect their anonymity. Juror D told me that he or she decided to reach out to me because he or she was uncomfortable with how the trial ended. He or she said that the last day of the trial was a whirlwind and everything happened fast. He or she recounted that his or her perspective was that the jury was brought into the courtroom, the note was read, the mistrial was declared, and the jury was then rushed out of the courtroom. Following a brief meeting with the judge, the next thing they all knew, the jury was on the bus. He or she described the end of the trial as very confusing. It says that once they were dismissed, many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know we acquitted Karen Reed on count 1 and 3? No one ever asked about those counts. Juror D told counsel part of his or her discomfort was that he or she knew that the jury had reached verdicts on 2 counts and Karen Reed might be retried on those 2 counts, and that's just not right. Juror D further stated, every one of us will agree and acknowledge that we found Karen Reed not guilty of counts 1 and 3 because that's what happened. And essentially, this juror even mentioned or suggested that they would have no problem testifying that this is true and accurate. I think at the very least, it would be appropriate for Judge Cannoni to bring in all of the jury members in a voir dire and ask them if they had come to any unanimous verdicts on any of these charges. Because, again, this is the life of a woman at stake. And the whole point of the judicial system is to ensure that people aren't retried for the same crimes. That's what double jeopardy is for. And the failures of the court to ask those questions and to tie up those loose ends, that's on the court. Yes, the defense could have said something, and yes, the prosecution could have said something, but they didn't. And at the end of the day, this trial is in the hands of the court. That's what the judge is there for, to ensure things are done properly so these types of things don't happen. And of course, the Commonwealth filed a document in opposition of the motion to dismiss, which isn't shocking. We kind of expected that to come. Now comes the Commonwealth in opposition of the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene after causing death, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. It goes on to say, the defendant's motion states that the court's decision to declare a mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Yet the defendant's motion and supporting affidavits of counsel inexplicitly omit the full opportunity that the defendant was given to be heard by the defendant's consent to the mistrial. Beginning on Friday, June 28, 2024, the jury sent a note stating, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. At that time, the court requested argument from the Commonwealth and defendant as to whether the jury had engaged in due and thorough deliberations. The Commonwealth responded that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue the deliberations. On the contrary, Attorney Yannetti argued, we believe that there has been sufficient time, and advocated for the jury to be declared deadlocked and provide the Tui Rodriguez instruction. Attorney Yannetti stated, the word exhaustive is the word that I think is operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they're at an impasse. This is the case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report they were not allowed to get. And I think the message has been received that the evidence is closed and they won't be getting anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with this at 3 or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there, which I do agree with that portion of what the prosecution is saying here, that David Yannetti was kind of pushing towards going to a hung jury. However, it still fails to ask their jury members if they had come to a unanimous verdict on any of these counts. So again, I think that this lies on the court. This is what the court is there for, to make sure things are done properly. If they had come to a guilty verdict on any of those, there wouldn't be a hung jury. But you can still have a hung jury and come to unanimous verdicts on other charges. Do I think the defense should have said something during the trial while the jury was in the courtroom? Absolutely, yes, 100,000%. But ultimately, I think that the judge failed in ensuring that there were no loose ends to be tied. The fact that multiple jurors are saying that they came to a unanimous verdict on multiple charges, it's a messy situation. And I don't think that bringing the jury members in for a voir dire would encroach on the laws that protect what happens in a deliberation room. It's simply just asking what the conclusions of the deliberations were. And I think that for the prosecution, I mean, If you think that all of this is unsubstantiated and based on hearsay or whatever, then you should have no problem bringing the jury members in. If you don't believe that they really came to a unanimous verdict, there should be no problem with that. So why not, going forward, why not ensure that that's not the case? If you're so sure that the jury did not reach a unanimous verdict on any of those charges, then you should have no problem proving that in the courtroom, bringing the jury out and asking them if they had come to any conclusions or any verdicts on any of those charges. It doesn't hurt anything, but I think that it would be better to have those loose ends tied up, because this entire trial, this entire case has already been given such a bad look for our legal system, for our law enforcement, for all of these things. You got to go back and fix the wrongs, make them right. Otherwise, you continuously have all of these people saying that this is a corrupt state. And it's like, you got to do something to try to redeem yourself and try to get any ounce of your reputation back for being just the way that a legal system is supposed to be. And it just looks so bad. And I also want to say that if in fact the jury did come to unanimous verdicts on those charges, it would be in the better interest for the prosecution not to retry those charges, because the public has been very vocal about thinking that this shouldn't have gone to trial in the first place, let alone go through another trial if she was in fact acquitted of these charges. Now, would they re-prosecute on the second charge, which was manslaughter while under the influence? I don't know. I don't know if that they would even retry that if it's just that single charge, because it was a lot of work, a lot of time. Again, a lot of reputations were destroyed. All of the police departments that were involved, the Boston police officers, the Canton police officers, the state police, all of their names were dragged through the mud. And from reports and things that I've read, the public doesn't really have very much faith and trust in these departments. So leaving this as a loose end, if the judge decides not to bring in the jury members to voir dire them and to getting to the bottom of this, it's just going to make it look even worse. So I really don't think that she has very many other options other than just dropping those charges, which I don't see her doing that. Seeing how she kind of handled everything, I think that she's going to bring in the jury members for voir dire. I'm not really sure how else you can fairly come to a conclusion. So we'll see how that goes. But getting to the reputations that were destroyed, we also found out once this trial concluded that Trooper Michael Proctor, the lead investigator in the Karen Reed case, the one that was texting all of those obscene things, he was suspended without pay. I see a lot of people asking, well, why wasn't he fired altogether? And these things take time. It's a process. So I do think that's going to happen. I think they're either waiting for him to step down voluntarily, but I do think it's kind of on the path of him being terminated altogether. Article from MSN says that Massachusetts State Police Trooper Michael Proctor, the lead investigator in the case against Karen Reed, was suspended without pay following a duty hearing on Monday. Proctor's duty status hearing was held virtually on Monday at Massachusetts State Police headquarters in Framingham. The veteran trooper was relieved of duty just hours after Reed's trial ended last week with a hung jury. He was transferred out of the Norfolk District Attorney's Office Detective Unit and into a Field Services Division in South Boston. Massachusetts State Police Colonel John Mon accepted the board's recommended suspension for Proctor on Monday, making it effective immediately. The length of the suspension was not immediately known. Proctor remains ineligible to perform tasks as a state trooper. Now, going back to this retrial, we already had all of these issues going on during this trial that made Trooper Proctor look very, very bad as the lead investigator. And adding, if and when Karen Reed faces a retrial, putting Michael Proctor on that stand after he was essentially fired for his conduct is going to make it look even worse. And again, I think that the DA stating that they had every intention of retrying Karen Read, I think that they're just acting on emotions at this point. It's more of a revenge type of trial instead of a truth and justice type of trial, in my personal opinion. Everything looks so bad, and they drug all of their police departments through the mud. I just don't think it would be a good idea for them to retry. And again, like, I think that knowing what the jury had to say on those counts, whether or not they found her guilty or not guilty, I think that's valuable information for not only the defense, but for the prosecution to have. It's important to know where you stood at that trial. And having that information perhaps can help determine whether or not you intend to retry. But again, I think that the DA kind of jumped the gun. They probably should have waited until all of this information came out. Because then we get to another article showing that Canton police officer Kevin Albert was placed on leave after Proctor's testimony in the Karen Read trial. A Canton police officer with ties to Karen Read murder investigation is now on leave. Officer Kevin Albert is the brother of the owner of the home where John O'Keefe's body was found in January 2022. Canton Police Chief Helena Rafferty says Albert was put on leave related to the testimony of Trooper Michael Proctor, the lead investigator in the Read case. The surprise announcement was made at a Canton State Board meeting Tuesday night, attended by Karen Read supporters. Chief Rafferty has placed Kevin Albert on paid administrative leave, said Michael Loughran, chair of the Select Board. Canton Select Board members say Kevin Albert, a Canton police officer and brother of Brian Albert, is now on paid administrative leave because of his actions on a case he investigated with Trooper Michael Proctor 2 years ago, but they didn't specify which case. Kevin Albert was placed on leave June 13th and will remain on leave until the results of the investigation are provided by an outside independent investigator, Loughran said. Albert was placed on leave the day after Trooper Proctor testified in the Karen Read trial. Read is accused of hitting and killing Boston police officer John O'Keefe with her SUV. Read and O'Keefe were dating at the time. Her defense claims she is a victim of a cover-up by several people, including law enforcement. Read's murder trial ended last week after a starkly divided hung jury failed to reach a verdict. Proctor has been suspended without pay after sending offensive texts about Read to his colleagues, family, and friends during the investigation. Brian Albert was called to the stand in the Read trial and testified that O'Keefe never entered the home that night. Now, I don't know if this will have any impact if there is a retrial, but why I think there might be is because it says that they're investigating a case that he did with Trooper Michael Proctor 2 years ago. The timeline adds up with the Karen Read trial. And they say that he was placed on administrative leave after Trooper Proctor testified, which leads me to believe that the case that they were talking about is the Karen Read case. But they're still waiting until this investigation is complete to decide what happens with Kevin Albert. But if an investigation does determine that it was Karen Read's case that they were investigating together, who knows if Kevin Albert will also be on the chopping block, and perhaps we will see him testify if there is a retrial. Again, perhaps if whatever results come out of that investigation, they'll decide not to, which at this point I think will be in their best interest. I think they are wasting even more time and money and will continually drag their departments through the mud once again. I don't think they have much to gain, especially if the voir dire comes out and the jury members determined that Karen Read was not guilty on those charges and she's acquitted of those charges. I can't imagine that they will retry her just on that second charge alone. But it doesn't really seem like they make the greatest decisions. So who knows? But it doesn't end there, because the Select Board member, Chris Albert, issued a public apology. Later in that meeting, the one where Kevin Albert was placed on administrative leave, Select Board member Chris Albert, Kevin and Brian's brother, issued a public apology. Chris Albert was also a witness in the Karen Read trial and has recent verbal arguments with people. He said, despite the tremendous harassment, stress, and anxiety that my family, extended family, and I have been subjected to over the past 16 months, my interactions were inappropriate, and as an elected official, I am held to a higher standard, Chris Albert said. Proctor's suspension was at the top of the mind for Read supporters at the meeting Tuesday night. The state police union called the decision to suspend Proctor without pay disappointing. He deserves to be terminated, and we need to rid our policing systems of all Michael Proctors, said Rita Lombardi. So it's wild. We have Michael Proctor, the lead investigator, suspended without pay. Again, I think that they are kind of inching their way towards terminating him altogether. I can't see why they would hold on to him if he can't perform any of the duties that he needs to be performing, that he shouldn't be performing. I don't think any department can have him on their force without the public being concerned about it. Having him be employed by any law enforcement agency will just look bad, and I don't think that they can gain or earn the trust of the public by having him on the force. So I think that he will be terminated if he doesn't step down first. Having Kevin Albert being suspended without pay, essentially he's on a vacation. But again, they said that the investigation is ongoing. So who knows what will happen at the end of that investigation. Again, they said that he was involved with Trooper Michael Proctor on a case 2 years ago, which lines up with the timeline of the Karen Read case. So if anything bad comes out of that investigation, I'm sure we'll hear about it if and when Karen Read is retried. And then we have Chris Albert, who is on the select board, who issued a public apology. There have been videos of him threatening people, saying that he's going to, or saying that he wants to beat them up and all of this type of stuff. So it's just a mess. But I think all of this happened, especially with Chris Albert, all of that happened while the jury was deliberating. I think that in his mind, he thought that this was kind of over and done with. I don't think that he thought that this would be going to a retrial. And I think that those incidents that he had where he was yelling at people on the street and threatening them, I would be very curious to see if that comes out in the trial. But it's a lot. It's a lot. I'm curious to see how this moves forward from here. I haven't seen Judge Cannoni issue any type of statement or anything regarding the motion to dismiss. I do know that the next hearing was scheduled for July 22nd, which is next Monday. And I imagine that we will hear about that motion and how she plans on moving forward. But this is crazy. I've never in my life seen anything like this. It's wild. But let me know what you guys think down below. Make sure you like this video before you go, and I'll see you guys in the next one.